Hello, welcome everyone. My name is Glenn Bates. I'm an attorney with Woods and Bates in Lincoln, Illinois. I'm going to discuss with you today the topic of preserving the family farm with trusts and LLCs. So there's several ways that we can hopefully preserve the family farm. Trusts and LLCs are one of those strategies. I'm going to go through some of that today. The best way to go forward is I have a presentation that's about 35 minutes. Go through that presentation. If you have questions as we go, just scribble those down, and there should be plenty of time for questions after the presentation. I'll stick around and answer those as we go. Okay, so when we talk about estate planning, it's good to start with a definition of what your estate is. So your estate is made up of everything that you own when you die. Okay, so all the assets that you have that are going to pass to beneficiaries, to your heirs, either by a will or a trust or some other mechanism. And when we talk about estate planning, that is planning for your death. So we're going to ensure that your assets pass to the people, places, things that you want them to pass to with the least amount of tax implications, hopefully. So when we talk about estate planning, one of the ways that we can do that is with what's called the last will and testament. So a last will and testament based plan is a document which is going to direct an executor that's nominated within that document on how your estate should be distributed on your death. So the way that works is the will gets deposited in the courthouse in the county of residence of the deceased. That will is going to nominate an executor. That executor is going to seek to be appointed by the court. This is what we call the probate process. And then that executor, once appointed, is going to collect the assets of the deceased, pay any debts, wind up their affairs, and distribute those assets according to the terms of that will. That will can also do things like nominate a guardian for minor children, can create trusts, it can do a lot of things, but as a baseline, it says, here's where what I own is to go at my death. Then we have what we call a trust plan. So there's many different types of trusts. What we're going to be talking about today is what we call a revocable living trust. And what that means is it's a trust created during a person's lifetime. What we do with that trust is we fund it with assets that that individual owns. And then that trust is going to appoint a trustee who's going to control the assets that the trust now owns. We say it's revocable because it can be changed, it can be terminated, whatever the person who created it wants to do while they're still alive. Usually the trustee that we appoint is going to be the person that creates that trust. It does not have to be. Even when we have a trust-based plan, we are going to have a will. In this case, it would typically be what we call a pour-over will. So it says I leave everything I own to my trust. Now, we don't want to use that will. Hopefully, we've funded the trust appropriately. We have everything owned in the trust, and we're going to avoid the need for probate with this revocable living trust. That's one of the advantages in having a trust. There's pros and cons to each, which I'll go over here in a second. But if somebody passes away and they don't have a will, they don't have any document that directs what happens to their assets, they're known to have died intestate. So when somebody dies without a planning document, their assets pass according to the laws of the state. In our state, Illinois says, here is your distribution if you don't come up with it yourself. Most times that is not what people want. So on our chart here that I put together, we have a will-based plan on the left, and then we have trust-based planning on the right. And as you will see in this first column here, we talk about what happens while the person is still living. So in a will-based plan, cost to create that plan, there's a lower cost up front. That's because there's a lower time commitment. So what we're doing is we're kicking the can down the road to when we pass away, and we're saying, executor, here's what I want you to do when I'm gone. Does not delegate any control of assets during your lifetime. You still own your assets. You still control those assets till you pass away. Then your executor is appointed. Then they would control those assets for you. That's different from a trust-based plan on the right side here. While there's some higher up upfront cost to creating this plan. That's due to the fact that there's some increased time commitment. We want to make sure, again, that that trust is adequately funded, getting those assets transferred from the individual to the trust. That trustee then controls those assets, but one of the advantages of the trust is that the successor trustee named in the document, so the person that takes over, if that person who created it passes away or becomes disabled, has access to those assets, so they can control those if they're disabled while they're living. So there's some advantage there too. After we pass away in a will-based plan, we have the court involvement, we have the probate process. That will gets admitted to probate, that executor appointed, and then that executor transfers those assets to the beneficiaries. It's a higher cost with this. Obviously, this is court process. Can be time consuming. There can be some delays in this, getting the executor appointed, getting access to the assets. There is no privacy with a probate process either. This is a public court document. So anybody that wanted to see those documents could see those. In the trust plan, when the grantor passes away, the person created the trust, we don't have any court involvement if we've done it correctly. So if it's been properly funded, our successor trustee is automatically vested with authority. They step in and they say, okay, here's where things are supposed to go. Hopefully at this point, there's minimal cost, minimal time commitment, no delay. That person is going to be automatically vested with authority to deal with those assets, and trust is going to have privacy. So the only people interested in the trust administration are going to be the trustee, any of the beneficiaries, and if the decedent had any creditors, they may be interested also, just by the nature of their relationship to the deceased. But that would be it. Okay, one of the things that's worth mentioning at this point is ownership and beneficiary designations. So what we've talked about is what a will says, you know, who I want things to go to, or a trust, here's how I want my assets to be distributed. Ownership, joint ownership, and beneficiary designations are really, really important when we're talking about estate planning, because how those things are owned and how your beneficiaries are listed takes precedence over the terms of a will or a trust. So for example, if I own my house in joint tenancy with my wife and I die, she's going to own that asset outright by operation of law. There's nothing that would need to be done because of the way we own that asset. Same thing with a beneficiary designation. If I have a life insurance policy and that lists my spouse as the beneficiary, claim's going to be made on my death, check's going to be written to that designated beneficiary. It does not matter what my will says, does not matter what my trust says. So we want to make sure that everything that a person owns gets where they want it to go in one shape or form. So we want to have a holistic look at it to see everything is aligning with our plan. This is not something that's stagnant. This can change. That's why we want to review it from time to time, at least annually, to make sure that our asset ownership, our beneficiary designations, our planning documents all say what we want them to say. Everything's going to go where we want it to go. You know, things change, life circumstances change, so those things may need to be updated from time to time also. Okay, so when we talk about estate planning, one of the things we get into is estate tax. And we live in the state of Illinois. So the state of Illinois has a state estate tax and there is a federal estate tax. When we are calculating the value of the estate for purposes of estate tax, whether that be the state estate tax or the federal estate tax, we are calculating the gross taxable estate, and that is everything that that person owned at the time that they died. Those taxing bodies do not care how it was owned. They don't care who the beneficiaries were, the joint owners, anything like that. They want to know what's the value of everything that that person owned. So we clarify this a little bit, and we designate some assets as non-probate assets, and we designate some assets as probate assets. So our non-probate assets, the things that are not going to be subject to a probate court process, are going to be assets that have joint owners listed on the asset. Those go automatically to the joint surviving owner, like we talked about. Anything that has a beneficiary designation, payable on death, transfer on death, those go to those listed beneficiaries. Anything owned by a trust is going to be going to the trust beneficiaries, and that's all outside of the probate process. So our probate assets are going to be assets that are owned in the deceased's name only. They don't have a beneficiary, they don't have any joint owners, and they're going to be distributed through the court probate process by either a will that says this is where my things are going to go. These are my beneficiaries, or the rules of the state. So intestacy. And that's going to be the heirs at law. In addition to trusts, wills, one of the mechanisms that we sometimes use when we're doing estate planning, especially in family farm situations where we start to encounter potential estate tax and trying to limit or eliminate that, is a limited liability company, or an LLC. And what an LLC is, it's a corporate entity. So it's a corporate entity that's established through a state of Illinois. You file articles of organization and you say, here's the owners of the LLC. And then one of the things that we do sometimes is we'll transfer ownership of the assets to that LLC. And in the event that we have somebody that has a trust, usually we'll have the trust own the interest in the LLC. This does several things for us when we're faced with having to try to plan or reduce or eliminate an estate tax. One of the things it does for us is it transfers real property, real estate, into a corporate entity. So now we own an interest in a corporate entity. We don't own real estate. The corporate entity owns real estate. So the person who owns the entity owns personal property. If somebody is trying to remove themselves from the state of Illinois by way of moving to a different state to avoid the state estate tax, we have now converted that real property to personal property. That's important because the state of Illinois still assesses a tax on a gross taxable estate that's in excess of their exemption amount, which is $4 million. And they use a fraction of here's what you own in Illinois over here's what you own total, and they apply that to the tax that would otherwise be due. So if we want to get somebody out of the state, this is one of the tools that we use. This ownership can make gifting more simplistic. So rather than trying to have appraisals done of real estate and figure out what fraction of the real estate we're going to give to a son or a daughter or multiple children, have real fractured ownership, 1/300th undivided interest, something like that. With the corporate ownership, we can say, okay, here's the total value of the real estate, and the percentage that we want to transfer is X. And that becomes pretty simple. So we're going to do some meeting minutes, and we're going to authorize the owners to do that. And then those new owners would join in the operating agreement to say, here's how we're going to agree to own and operate this limited liability company. Payment of the income in the LLC is payable to the owners according to their ownership interest. So that's how the income is going to be distributed ultimately. It helps to operate farms. When you start getting more people involved, it gives you a mechanism to contract with your tenants to say, okay, you're going to be a tenant of the LLC, and then the LLC is going to deal with the income once it comes in. It's going to distribute according to our ownership. Has some other advantages that we'll go through momentarily. We typically will have a trust own the LLC. That's going to be for probate avoidance and for asset protection. So that trust could continue potentially after the person who created it's gone, to hold ownership of that LLC and then distribute income to beneficiaries, protect what that LLC owns from the beneficiaries' creditors, maybe divorcing spouse, judgments against them, bankruptcy, bad spending habits, substance abuse issues, etc. So we can use the mechanisms that we have in place to protect the asset from the beneficiaries and protect the beneficiaries from themselves. So this is a visual of how that would work. So we have on this outer ring here, what we've titled as husband. And if it was a husband and wife, we would have a similar ring that said wife. So here's what husband owns, here's what wife owns. So if we equally divided those approximately, husband owns half, wife owns half, into a trust for each, and then we transferred the real estate to an LLC, what we would end up with is we're going to have husband's trust owning 1/2 of the interest in this LLC, wife's trust owning 1/2 of the interest in this LLC. Okay. And then in the event that there's an estate tax issue, this trust for the first to die is going to hold those assets for the benefit of the survivor and keep those assets outside of the estate of the survivor. So when we're doing things like this, when we're drafting estate plans, there's several things that we need to consider with clients and discuss. One of the main things in the topics that we're discussing today is, do we need to limit estate taxes? We figure that out by compiling a list of assets. We look at how those things are owned, beneficiary designations, and then the value of those assets to come up with a total to see, are we above or are we below the estate tax exemption amounts? Then we talk about who, where, what we want things to go to. Do we need to protect the heirs from themselves, like I discussed earlier? Who do I want to fill some of these roles that we're creating? Who do I want to act as executor? Who do I want to act as trustee? If those people can't act, who could act in their place as a successor? Those types of things. Okay, if I have minor children, who do I want to care for those minor children? The state of Illinois divides the guardianship into guardian of the estate and guardian of the person. It can be the same person or it could be different. Guardian of the estate would be who's going to manage any money that that child owns until they attain the age of adulthood, 18 years. They may not have any money, but the guardian of the person is going to be the one that deals with kind of raising the kids. Who's going to take them to school? Who's going to take them to the doctor? Who's going to make sure they're brushing their teeth in the morning? Those types of things. So again, that can be the same or different people. We need to nominate successors for those people too, if they can't or won't do it. Do I need to create trusts for my minors? Do I need to hold assets longer than what our society says makes an adult 18? Do we think that at 18 years of age they would be able to handle an inheritance, a significant amount of money? Maybe, maybe not. If we're going to create that trust, who's going to act as that trustee? And then, do I want to make any specific bequests? Those things need to be outlined in the planning documents with specificity. Another consideration when we're doing this type of planning is gifting. So when we're talking about giving gifts during somebody's lifetime, any individual can give a gift to any other individual in a calendar year that does not exceed $18,000 without the IRS saying you need to file a gift tax return. So if I give a gift of $15,000, no gift tax return required. Now, if I give a gift of $50,000, IRS says you are required to file a gift tax return. What that gift tax return will likely do is create some unintended consequences, because there's probably not going to be a tax due at that time. But gifts that have tax returns filed bring the value of that gift back into the estate when we're calculating the gross taxable estate that we talked about earlier. So it does not totally divest you of those assets for purposes of estate tax. There's some other issues with gifting. Recipient of a gift usually takes the donor's tax basis in the property that's gifted. So in farm situations, if we're giving real estate, the person who's making the gift has a certain tax basis. That's either the value of the property when they purchased it, or the value of the property on the date of death of the person who they inherited it from. That basis is probably very low compared to the value today. If somebody sold it, their gain is going to be the difference in the sale price and the basis. So we're eliminating one of the advantages by gifting versus inheriting. So when somebody inherits, they get a step up in tax basis to the value at date of death of the person they've inherited it from. That can be fairly significant. And that's important if somebody sells the asset. Okay. One of the other unintended consequences of gifting could be Medicaid ineligibility. Medicaid, when you apply for Medicaid, they don't care about the $18,000 threshold. What they ask is, have you given any gifts in the last 5 years? And if you had, that creates an ineligibility. That's a topic that's pretty in-depth and worthy of more time, but we're not going to get into that today. So here's some statistics for you. Illinois has an estate tax exemption amount of $4 million, as we discussed. The tax in Illinois is about 28.5% once you get over 4 million, and that's regressive. So it kind of goes down as the value of the estate goes up. Federal estate tax exemption amount is much higher. Right now it's 13.61 million. That's about a 40% tax rate. But as you can see, one of the taxes that we mainly focus on is the Illinois estate tax because it's much lower. The federal estate tax has what's called portability. So in a spousal situation, if the first spouse that dies does not use the full 13.6 million, they can make some, their surviving spouse can make some appropriate tax filings, and they can secure the remaining amount of the deceased spouse's exemption. So they can increase the value of their exemption in that amount. Illinois does not have that portability. Illinois' estate tax exemption amount is a use it or lose it exemption. So if you die and you do not use your exemption, you lose it altogether. Now, in both systems, the spouse can leave to the surviving spouse any amount of money and it's totally exempt. The problem comes in when the survivor dies, then they own everything. So then they have a massive tax because they have not taken advantage of the first spouse's exemption, especially in Illinois. So we're estimating here cost of planning to be $3,000 to $10,000, and that all depends on complexity and what types of things we're doing, what we're planning for. Is there estate taxes or not? But that's a range for you for the sake of the example. If we look at the Illinois estate tax on an estate that's valued at $5 million, that estate tax is going to be about $285,714. So it's pretty significant. If we look at a estate in Illinois that's $8 million, so a gross taxable estate of $8 million, tax that Illinois is going to assess on that estate is $680,634. Very significant. So that's a significant amount of money that the beneficiaries are not going to receive, and they're more than likely going to have to come up with a way to pay. Because keep in mind, and what we're discussing today are farm businesses. And so the large majority, typically, of people that are planning for farming businesses, the value is in the real estate. That real estate is not liquid. That real estate is not available to pay things like taxes. So then if there's a tax due, we have to look at alternatives to pay that tax that are typically not appealing. If there's cash available in the estate or in the trust, we can use that to pay the tax. It's going to be a significant amount of money that's not going to go to the beneficiaries, and it's going to go to tax. If there's not money there, we would have to potentially mortgage the real estate to raise the cash to pay the tax, maybe sell the real estate. And, typically from what I've experienced, that is the last thing that people that are planning to try to pass on a family farm want to do. They don't want to have it sold. So we can try to avoid these taxes and avoid those scenarios. And we believe with a married couple of up to about $10 million, if there's appropriate planning done, we can essentially eliminate that tax. So if we don't plan, there's going to be some consequence. If we do plan, I think we can do quite a bit of good for the beneficiaries and save the beneficiaries quite a bit of money in tax. So taking that example a little bit further, husband and wife own, say, $10 million in assets. If we don't do any planning and, maybe we have a simple will that we've printed off LegalZoom and it says I leave everything I own to my spouse and we own everything jointly, what have you. Surviving spouse owns all those assets at death. When the surviving spouse dies, the Illinois estate tax on the surviving spouse's estate is going to be about $1 million. Okay. And that includes, I think, probate fees and appraisals and things like that. So that's not necessarily all tax, but it's pretty close. It's pretty close to $1 million in tax. After 2026, if Congress doesn't take any action, that $13.61 million exemption comes back down to $7 million approximately. So after 2026, we could potentially have a federal estate tax issue as well on this particular estate. So more than $1 million may be due. And we already talked about, what are the solutions to pay that tax? Because in our scenario, probably 8 or 9 million of that value is farm real estate. So if we do some of the planning that we've discussed, we're going to create an LLC, transfer the ownership of the real estate to the LLC. We're going to create trusts for each of the spouses. Each trust is going to own a 50% interest of the LLC. Each trust then is also going to own about 50% of anything else that they own. So each trust owns about $5 million in assets. One of the things we can do is we can start to take discounts in value now because we have divided ownership. We have things like lack of marketability. We have, lack of saleability because we have created these things like the LLC and the trust, and we've divvied out the ownership between those trusts. So if we can take 20 to 30% discounts on these assets, surviving spouse is going to have in their gross taxable estate around $5 million. Okay, that's going to be exempt from federal estate tax no matter when that is, because even after 2026, that's going to be less than 7 million. We're above the 4 million in Illinois at the total. But if we take discount valuation, if we take even just 20% of a discount, we're down below 4 million. So now we've taken what was $1 million plus in tax that was going to be due when these two people died, and we have created zero tax due at both of their deaths. And we've passed the total value of $10 million on to the beneficiaries in some way, shape, or form. Maybe these trusts said we want the ownership in the LLC to go to our 5 children equally, once we're both gone. So now 5 of the kids each have 20% ownership in that LLC, and it gives them a mechanism to continue to operate that farm as if nothing happened at all. Income's still going to come into the LLC. LLC is going to file income tax returns. LLC is going to pay out the net income to those new owners, just as it did to the trusts previously. One of the things that this would allow us to do is some gifting during lifetime also. So once we've created this LLC entity, we could value that entity, say it's worth $10 million, and we can pretty easily calculate what percentage of that LLC we can give away to keep ourselves under this $18,000 each year and start to divest ourselves of ownership of those assets. So that's a way that we can start doing that while we're still alive. This is going to serve a couple purposes. It's going to start to reduce the value of the gross taxable estate of the husband and wife that created the plan, but it's also going to start to transfer ownership to our beneficiaries, to our other family members. So maybe we transfer 0.01% to 5 kids while we're still living. We get an operating agreement together. We have 2 trusts and we have the 5 kids as owners of the LLC. There's restrictions in that operating agreement as to who can inherit the ownership of this LLC, how those interests are going to be bought out in the event somebody wants to sell. All those things are clarified in that operating agreement. And what it does, it's going to restrict how or who those assets can be transferred to after mom and dad are gone. So if the husband and wife in our scenario just said, I want our farm to go to my 5 kids equally. So mom and dad pass away, we deed that out from the trust or the estate, whatever the case may be. Each child would own then an undivided 1/5 interest in that farm. As an undivided owner, you have certain rights under the statutes of the state. You have the right to force a partition if you want to. If you say, I want money, I don't want real estate, you have that right to force that issue. And then those other owners have to start figuring out how to come up with money to buy you out at the price you want. Or, a judge somewhere along the way may say, list it for sale, auction it, do those things. And an undivided owner has those rights. Owner of an LLC doesn't necessarily have those rights when it comes to real estate because they don't own the real estate. They own the LLC. So these things can be very, very valuable to accomplish a lot of the goals that these clients we have seen set out to achieve. I don't want the farm to be sold. I don't want the kids to argue about how it's going to be managed, et cetera, et cetera. Well, these trusts, these LLCs can help along the way to do that. And I think involving the family in the ownership and operation of the business helps them when the main business owner, if you will, isn't around anymore. Get some familiarity with the process and how it works, dealing with the tenant, selling grain, whatever the case may be. So in summary, everyone's circumstances are obviously different. I've given you some scenarios today, but we believe that estate planning needs to be specifically tailored by the attorney and the client to meet the client's needs. Some people have goals that other people don't. Those are different. And these types of plans, especially that we've discussed today, need to be reviewed and revised to remain current. If we get into a schedule of gifting, for instance, we want to make sure we're doing that every year. We're looking at those values. We're making sure we're staying under the exemption amount for gifting so that we don't have problems later on. And these types of plans, along with any plan, are going to make your wishes known. They're hopefully going to involve beneficiaries and family members sooner than later, get them invested in the process, get them to start understanding how these things work, and hopefully avoid confusion and feuding when mom and dad pass away. Confusion and feuding equal attorney's fees, litigation, fighting. And that's the things that we want to avoid with estate planning. So it's forward looking to make sure that we have everything lined out the way we want it and that it works the way we want it to work. And it can work in that way if we put forth the effort to do it. So thanks again for coming.